I apologize for my delay there, but I wasn't sure if appearances had to be announced by my learned friend. I had quite a bit of homework to do. I have done my best. I now understand why I was asked if I could achieve it all. It was very difficult. But I begin with clarifying an issue with Dr. Manning Aline. I had responded to my learned friend yesterday when he had made the oral submission that the actions of Dr. Manning Aline were for the benefit of Karen Lezama on behalf of the appellant. And the brief submission that I had made was that she has, at different points, been cast in the role of friend by the appellant, and now he was attempting to rely on her actions and to appropriate them. And I did locate in the electronic bundle at page 1072, which is the Court of Appeal transcript of the hearing, the appeal hearing before the Court of Appeal, at lines 14 to 18, where it is asserted by counsel for the appellant that the appellant was in the throes of an emergency whilst Manning Aline was there with her friend. Another issue that I would have submitted on yesterday was the amount of blood. My submissions would have followed on from my learned friend's submissions, and I have extracted several references in relation to the amount of blood that I would like to go through and provide those references now. Beginning with Brian Lezama, the board made reference to Brian Lezama's evidence. He is the husband, and I have isolated the several paragraphs in which he describes the blood flow as it appeared to him. His witness statement is found at the electronic bundle pages 714, and at page 717, paragraph 17, in the last line, he describes a gush of blood and fluid covering all in its path. At page 717, paragraph 18 of his witness statement, he refers to Dr. Achong Lau having complained of profuse bleeding. At paragraph 19, page 718 of the electronic bundle, he describes the linen on the delivery table as being fully drenched and that it was overflowing on either side of the table. The blood, that is. Paragraph 20, page 719, the river of blood had reached 3 to 4 feet in either direction. The quality of the blood is also observed by him to have changed and to have become more watery. I specifically referred to the evidence of Petronella Manning Aline yesterday as being corroborative of Brian Lezama's account. The references in her witness statement, paragraph 8, page 759. As soon as Karen delivered, she started bleeding profusely. Under cross-examination, the references to her description of the blood and the continuing trickle of blood are at page 481, lines 36 to 50, and page 482, lines 1 to 2.
Sorry, what? I can't see those. You say 481?
482. Oh, sorry, 481 lines 30. I'm sorry, that's on air hunger.
Yeah.
Yes, I copied and pasted it into the wrong zone. My apologies. Which I will come back to, because that's another aspect that I'm filling in. So it is only, the only reference then is in her evidence in chief.
Which page was that?
Sorry,
That's 759, that was the one you referred us to, was it? Or-
759.
759, paragraph 8, and then there is a reference at page 760, paragraph 12. To constant bleeding.
So I think the Court of Appeal quoted the dramatic evidence from Mr. Lezama, didn't they, in their judgment?
I'm sorry?
The Court of Appeal quoted Mr.
Yes.
Lezama's evidence in
They
their
did.
judgment.
They
Yes.
did. The agreed, still on the amount of blood, the medical notes, as contained in the agreed bundle of documents, at page 964, at 5:15 p.m., the patient is recorded as still bleeding. At page 973 of the postpartum notes,
Bear with me, you're going a little bit too fast.
Sorry.
We've got the page, that's 964 in front of us, and
Where
where
is
do
it
we
now?
see that?
page 964.
Yes.
It's difficult to see.
Well, I mean, but if you are referring to a passage, then give us a chance to see it.
Of course, I apologize.
Whereabout on that page?
I will pull it up as well. It is in,
3 lines up from the bottom.
it's the admission form in the, it begins, so at 964, the page begins admission, and it is closer to the bottom half of the page. It's a bit cut on the
There are
side.
some weight and other details in the middle of the page. Is it below that?
Yes.
Is it 3 lines up from the bottom? And you,
Yes, it is.
yeah.
Patient still bleeding. Thank
This is
you.
still bleeding, yes. That's after the hemocell was applied, yes.
Yeah, according to this note, yes.
And do we have a time for that?
We have a time, if you look to the left in the page, the line right above still bleeding, you'll see Ringer's lactate, and if you go across to the left,
Yes.
you will see 515. It's not
Yes,
easy to read.
Yes, indeed.
At page 973, same medical notes in the agreed bundle of documents. These are the postpartum notes prepared by the appellant. These postpartum notes, he records significant bleeding. I will attempt to locate on page 973 the approximate location of it.
If you go, it's about halfway down. There was significant bleeding,
Oh, yeah.
Yes.
which appears to be related to a repair, which often something.
I think it's which after repair
Yes,
of a median laceration at the post-Fouchette.
yes.
The PPH was controlled by IV syntocinon drip and fundal massage. And then next to that is a symbol in brackets with 500 cc's. And my interpretation of that is over 500 cc's is the estimated blood loss.
Or is it about?
Approximately.
Isn't that a
Yeah.
symbol?
I'm not
I think
sure.
so.
Yeah.
While you have that note open, and it may be a matter really for Mr. Benjamin, there doesn't appear to be any reference to AFE in the appellant's note, which is recorded as being made immediately after the death.
Yes, I have that in a note today as well, so that now that the board has recognized that, I won't be addressing further on it. But yes, there is no reference to AFE in the postpartum notes. The only other reference that the appellant makes in the postpartum notes to the patient bleeding is when he states that she started to bleed again after the decision was made to transfer her to an ICU. And that is
At the bottom of that page,
bottom of the
that
page.
patient began to bleed again.
yes.
It's just towards the bottom of 973.
From all,
Decision to transfer to ICU
For further management.
management, but patient began to bleed again.
but then it also says PV and from all something sites and orifices.
Yes.
Or vein punctures. Vein punctures. So any punctures of the veins, presumably.
Yes.
Were these notes transcribed into a
No.
more legible form?
I'm sorry?
Into a more legible form?
No. This is the note as produced by the maternity clinic.
Yes. But there's been no transcription since for the purpose of the
There
proceedings.
has been no transcription for the purpose of the proceedings. Unless I am mistaken.
Well, I could be mistaken, and I need to double check it. I thought there was a transcription of it in one of the two judgments, whether it's first instance or Court of Appeal.
Not that I,
Well, then I'm
but
sure
I was not
then
at
I've
first
got it
instance
wrong.
or in the
I've got
Court
it
of
wrong.
Appeal. So if I am wrong, I apologize.
No, no, no.
Certainly not of all the notes, I think. Maybe some.
If
No,
I can
just
assist,
the,
my lady is absolutely right. It's page 227 of the electronic bundle,
Thanks very much.
where Justice of Appeal Barrow and the rest of the court transcribe the entirety of the postpartum note.
Postpartum note, yes.
I apologize, but I thought that the question that was posed by Lord Kitchen was as to whether a medical transcriptionist or a qualified person had transcribed it.
No, I just want, for our benefit, there's been no issue as to the correctness of this transcription that we've got in the bundle at 227, has
It
there?
hasn't been challenged.
Yeah.
And I'd like to go next to the agreed statement of facts and issues, electronic bundle, page number 1152, paragraph 12. She immediately began bleeding significantly, and the blood was initially thick and red. And then finally, to the evidence of Dr. Mary Singh Bola. Her report is contained at the electronic bundle, pages 911 to 927, and at page 917, she opines that estimates by caretakers are usually incorrect. It appears immediately below the table that is set out therein. Table followed by studies have shown that caregivers often underestimate visible blood loss by 50%. In terms of the acute respiratory distress, there is a matter of housekeeping. The board had raised yesterday that there was a potential inconsistency between our agreed statement of facts and issues and our chronology at 5:15, but in fact it's not an inconsistency. The two documents are the same. What is unusual is that we have two blood pressure readings, but that is lifted directly from the medical notes, which has two blood pressure readings at 5:15. I don't want to speak for my learned friend, and it is not a matter that we have discussed, but what appears is that they took the initial blood pressure reading, there was some treatment, and then there was a second blood pressure reading within the window of 5:15 to the next note at 5:45.
Yes, but both were pretty alarming blood pressure readings.
Both were low.
Yes.
But I did want to clear up that it's not a discrepancy as such between the two documents that were put before the board by the parties.
Thank you.
Acute respiratory distress. Respiratory distress was identified by my learned friend as in response to a question posed by Lord Legat. And excuse me if my note is not entirely accurate, but I did try to capture it verbatim. Is there any factor that tends to suggest that the cause was not uterine atony causing PPH? And the response was respiratory distress. And the respiratory distress, I then went to locate as many references as I can on respiratory distress, beginning with the statement of agreed facts and issues, which I would have submitted yesterday, does not deal with it, but I wanted to check. There is no reference to acute respiratory distress. The statement of agreed facts and issues, electronic bundle pages numbers 1151 to 1160, they are set out. The relevant agreed facts as to the treatment are set out at electronic bundle page numbers 1151 to 1154, paragraphs 1 to 30. There is no reference to acute respiratory distress. There is eventual reference to cardiac issues arising, but no reference, particularly in the early stages to the mid stages, to any acute respiratory distress in the agreed statement of facts and issues. I've already given the reference for Dr. Manning's by accident in relation to the blood, but I will give it again. And that is page 481, lines 36 to 50, and page 482, lines 1 to 2. As was observed by the board yesterday, Dr. Manning's evidence places air hunger closer to 7:30. Turning to the medical notes contained in the agreed bundle of documents, electronic bundle page numbers 951 to 985, and beginning with the nurse's notes, electronic bundle page numbers 964, 967, and 968. There is no reference to respiratory distress on page 964. The first reference to the patient being ambu-bagged is at 7:40 p.m. on page 967.
Can we look at that?
Sorry.
These notes, these nursing notes, don't appear to start until 7:30.
The nurse's notes start on the admission form that we looked at in relation to the bleeding, and then these notes appear to start at 7:30. And then there are some notes that come after it that the precise timing is unclear as to whether it's the middle or a repetition of portions of this, as there are some similarities.
Are those the notes you're referring to at 969?
Yes.
Right.
Because if there are some unique events recorded in the beginning of these notes, which are synonymous with what is in the notes that have a time that is clear. So it cannot be that this is a follow-on. It may be covering a portion of the middle and have some repetition. I don't fully understand it.
Well, it's not unknown for medical notes or nursing notes to be out of order when they get into agreed bundles.
I did wonder if that was it, but because of some of the events at the beginning that are the same as some of the notes on 967, which are not events that happen more than once, perhaps it is a rewriting.
Sorry, for my benefit, just drawing your submission together on the nursing notes, 964 through 967, 968, 964, 967, the respiratory distress appearing later. Your submission is?
My submission is that there was no acute respiratory distress recorded in the nursing notes until the first reference to ambu-bagging at post 7:30.
Yeah.
But it does say patient continues to be ambu-bagged.
So we don't know when it started?
We don't know when it started by reference solely to the notes, but there is evidence coming from Dr. Manning Alain placing it closer to the time of 7:30.
Thank you.
And there is also a note coming from the appellant, which I will go through after I complete the review of the medical notes, the nurse's notes.
And the Dr. Manning Elaine's evidence, was that back at 481, 482?
Yes.
Thank you.
Her oxygen saturation when she's ambubagged at 7:40 p.m. on page 967 is identified as 97. Her next recorded oxygen saturation on that page, which is 967, is 98 at 8:40 p.m. On page 969, the precise timing of those notes are uncertain, as I've already canvassed, but there is an oxygen saturation reading of 92, which increases to 97 after the first unit of blood is administered. The appellant identifies an oxygen saturation reading of 92 in his witness statement, which I can give the reference for. Apologies.
Well, his witness statement is page 772, I think, paragraph 24.
I'm grateful. That is where the oxygen saturation is recorded.
I don't think there's anything in his statement that I could see that refers to any respiratory distress, apart from describing it as a feature of AFE, but he doesn't say he observed it in her case.
Doesn't say that acute respiratory distress presented, no. And then in his postpartum notes, at electronic bundle page numbers 973 to 974, there is no reference to acute respiratory distress. There is a reference to treating the patient with syntocinon and fundal massage, and refers to the blood pressure as being, I think, shocky. And there is assistance on the ambubagging, placing it in time, because according to the appellant, they only start ambubagging the patient after Dr. Chang has been called. And we know that Dr. Chang was called at 7:30. And that is agreed. And so my respectful submission on the issue that arose yesterday when my learned friend was questioned on it is that there was in fact no evidence of acute respiratory distress.
Before 7:30, or at all?
Before 7:30.
Yes.
As to whether it was
at which
acute,
time she was almost dead, according to
several of the witnesses, yes.
Yes.
Very briefly on the availability of blood, I have already made extensive submissions on that, and it is covered in my case, but I did want to bring to the court's attention paragraph 3, Roman numeral 2 of the respondent's case at the electronic bundle, page 1199. Where the statement of Waveney Charles is referred to. This evidence went in by consent. It has previously been referred to as untested, but as canvassed in our case, it went in by consent.
It's somewhat succinct, as I recall.
It is very succinct.
Yes.
But sufficient. Sufficient. Another issue that arose yesterday was the timing of the blood. The appellant was cross-examined on the timing, and I believe that question was raised and references needed to be produced. He was cross-examined on the timing by Senior Counsel Stanley Marcus. And this is at page 661, lines 47 to 51, and at page 662, lines 1 to 9. I do not have it excerpted. I was unable to type out all of the references, but I do have my own submission to make on it. I've given the references, and I would like to share my submission, which is that he attempted to evade answering the questions posed to him on the timing by posing questions in response. But he eventually admitted that the blood was administered late. He claimed that there was a reason. He was given the opportunity to identify the reason, and what he identified is that that was when the blood arrived. I made the submission yesterday. I repeat it briefly, that it was always available to him to obtain blood from St. Clair. He received it on demand. He discloses a relationship. He made no request of the blood bank. Blood was available. And on the evidence of the appellant, it was late.
Well, one of the striking features is that the first attempt to match the deceased's blood was very late in the day.
It was 6:40.
Was that put to him or not?
I don't believe the cross-matching, the late cross-matching was specifically put to him.
No, okay.
I could be wrong, but
Could you just help me, please, in terms of the cross-matching? You do a test on the patient to see their blood types, presumably.
yes.
You go to the blood bank or wherever it is you're going to source your blood from, and they would already have tested the blood, would they? In
the blood bank?
Or
Yes.
is that,
You ask for the type that matches the
Yeah.
patient.
Yes.
so no further test needs to be done on the blood that you're going to administer?
I don't want to say the wrong thing. My own understanding of cross-matching is that it may be, I believe that it is simply that you test from you confirm the blood type of the patient and you get the blood from the blood bank and you administer it.
Yes.
I don't think that there's any additional test where you take a sample and because there is that type of equipment is not likely to be available in the average nursing home.
So your submission is that you could have tested the patient's blood at any time?
Of course, yes.
Yes.
Yeah.
I mean, it's an agreed fact in the Statement of Facts and Issues that
Yep.
the blood was taken from Mrs. Lezama for cross-matching at 6:40.
It is. I would like to move on to the expert evidence with a specific reference to first instructions. It is a point that I raised yesterday. And I raised it in response to my learned friend's criticism of Dr. Mary Singh Bola. In relation to each expert, I'd like to identify where their report can be found and where their letter of instructions can be found. Beginning with Dr. Raul Jabode, his report is at electronic bundle, pages 943 to 950. And the letter of instructions dated the 21st of June, 2011, issued by Anthony Bullock, is at the electronic bundle, pages 943 and 944. Dr. Mary Singh Bola, her report at electronic bundle pages 911 to 927, with the letter of instructions dated the 1st of April 2011, at electronic bundle pages 924 to 927. And to respond to a question posed by the board yesterday, there was no objection taken to the report of Dr. Mary Singh Bola. Dr. Hemant Prasad, there is an affidavit inclusive of exhibits. His report is an exhibit to his affidavit, and the total affidavit inclusive of exhibits spans electronic bundle pages 777 to 903.
The report itself?
The report itself is at electronic bundle page numbers 899 to 903. The letters of instructions, there are multiple letters. There is letter dated the 29th of September 2009 from Hamel-Smith, electronic bundle 781 to 782. Letter of instructions dated the 4th of February 2011. This is the comprehensive letter of instructions, electronic bundle page numbers 786 to 895. And the length of that is attributable to the attachments. There are several attachments, including the agreed bundle of documents.
And this was the expert who was originally instructed on behalf of the second defendant against whom, by consent, proceedings were discontinued.
Yes.
And thereafter was called by the appellant.
Yes. And there is a letter of instructions, which is more in the vein of a follow-up letter requesting the report, and that is at electronic bundle 897. And Dr. Hubert Daisley, the report inclusive of instructions at electronic bundle page numbers 928 to 940. The letter of instructions dated the 1st April 2011, electronic bundle numbers 937 to 939. I'm particularly concerned to repeat that the instructions given to Dr. Jabode were inadequate, and that a simple cross-referencing with these other letters of instructions issued to all other experts will demonstrate that. But in particular, his comparator is Dr. Mary Singh Bola, and the differences in their letters of instructions are considerable. Despite those differences, and despite the fact that Dr. Jabode, he receives several pieces of information that are not even borne out on the agreed facts, one of which is that from the beginning of the bleeding, it was pale. When the agreed facts I've already demonstrated, it was significant, it was red, it was thick. He is told that the diagnosis of AFE was made. He is provided only with the agreed bundle of documents and the witness statement of Dr. Achong Lau. And despite that, he still advances several opinions that assist the claimant.
So can I just get this clear? When those documents were sent to him, he wasn't sent any of the original notes, medical notes, nursing notes?
Those are in the agreed bundle of documents. So that when my learned friend says that this case turned upon a battle of the experts, it truly is not a battle. There are several points on which the experts are ad idem, despite the inadequacy of the instructions issued to Dr. Jabode. And the evaluative exercise does not give rise to a miscarriage of justice. That has not been demonstrated to the board. In terms of the appeal that is before the board, I've already made submissions in my case, and I don't want to repeat it, but the appellant has not, in my respectful submission, demonstrated or adduced any ground capable of persuading the board to interfere with any of the findings or the decision of the Court of Appeal. I'm not going to repeat the discrepancies between the notice of appeal and the case. I canvassed that extensively in my case. But I will, on the issue of causation, take the board to the notice of appeal filed before this board. But before that, I wish to take the board to the notice of appeal filed in the Court of Appeal. And that would be at electronic bundle page 125. And at electronic bundle page 126, under the rubric details of any finding of fact which is challenged, I have identified only 2 findings of fact that were challenged that go to causation. And that would be number 2, Roman numeral 2, and number 2, Roman numeral 4. In relation to 2 Roman numeral 2, the finding of fact that Dr. Bola concluded that PPH was a more likely cause of death than AFE. And 2.4, the finding that on a balance of probabilities, the deceased's death was not due to AFE. These are the only findings of fact appealed which are capable of going to causation. And as the board will note, AFE is bundled up in any challenge to causation. The grounds of appeal begin on 127. From the bottom of the page, you'll see 4, and then the rubric grounds of appeal. And the only grounds of appeal that I'll be referring to relevant to causation are found at page 128, 4 Roman numeral 2. I will have to read it. The learned judge erred in law and in fact in finding that Dr. Bola concluded that PPH was a more likely cause of death than AFE. This finding by the learned judge is unsupportable and completely disregards the fact that PPH is a description of an event rather than a diagnosis, and the cause of PPH must be determined. The learned judge failed to give adequate and/or sufficient weight to the facts that Dr. Bola accepted in cross-examination, that PPH is a description of an event rather than a diagnosis, and importantly, that a diagnosis, and I'm assuming here all these diagnoses are supposed to be diagnosis, of AFE is done clinically. B, that there were a number of symptoms that must present themselves for a clinical diagnosis of AFE, and the vast majority of these were present. And C, Dr. Bola conceded in cross-examination that it was reasonable to conclude that the deceased had suffered PPH as a result of AFE. So again, this ground of appeal at 4.2 bundles up AFE and any challenge to causation. Moving on to page 130, and that would be Roman numeral 4, Roman numeral 17 and 19.
Roman numeral, which was the first one you mentioned?
17.
17 and 19.
And 19. The learned judge erred in law and in fact in finding, this is 17 I'm reading, and in finding the appellant negligent on 3 counts, and furthermore that the facts that he, the learned judge, relied upon for each of these findings caused the death of the deceased, especially when the overwhelming evidence was that the death of the deceased was caused by AFE, and that PPH is a description of an event, not the cause. So I say first that, again, it bundled up with AFE at the end, but I particularly draw your attention to this ground because the clear understanding of the appellant in the articulation of this ground of appeal is that having found the appellant negligent on 3 counts, he relied on those findings to substantiate his causation finding, which is that they caused the death of the deceased. It is apparent on the face of the judgment as well, but I did want to particularly point out that though he understood the trial judge's finding to be on negligence, these 3 heads of negligence which have already been discussed, and that they caused the death, he does not in any other way challenge the cause there, save to tie it to AFE.
Yes, the argument seems to be that I think it's clear when you read the appellant's written case before the Court of Appeal, the attack is on the judge's failure to find on balance of probability that the cause was AFE.
Yes.
And there was no separate challenge to causation if the court was entitled to conclude that it wasn't AFE.
Yes, that is my submission, please.
Yes.
In terms of 419, it is a general ground of appeal at page 131, but in which the appellant contends that the learned judge's conclusions on the issues of fact and law are wrong in fact and law, but it takes the appeal no further.
Yes, 418, we can see the matter focused.
Apologies, yes, 418.
The attack is failing to find that the deceased's post-partum hemorrhage was caused by AFE, which ties into this argument that it was simply, it wasn't a diagnosis, it was simply an event.
Yes. Grateful, my lord. So this was the notice of appeal that was before the Court of Appeal. And as the board has already noted, the attack on causation was premised and tied at all material times to AFE. Similarly,
the event argument, that it's not a cause but an event, suggests that the way the case was being argued, at least then, was that the only significance of AFE was that it caused the hemorrhaging.
One of the things.
And that was the mechanism by which AFE operated. If that were correct, it's hard to see what the relevance of AFE would be as an answer, since if it's accepted that the hemorrhaging was the cause of death, and that's what the defendant failed to address.
Yes.
It really has to be, if it's going to go anywhere, an argument that AFE operated by a different mechanism, which wouldn't have, which was separate from the loss of blood.
Yes, my lord.
And therefore would have operated anyway, even if the blood loss had been addressed.
It was what was trying to be argued by the appellant, but is rejected by the Court of Appeal. The notice of appeal to the board is at electronic bundle page number 288. I apologize. This is where the grounds are set out. So I'm taking you directly to the grounds. And the only grounds that deal with causation are that of 6D, 6E, and 6F. The Court of Appeal erred in finding, this is 6D, erred in finding expressly when Rahim J. did not, that Dr. Achong Lau's treatment of Mrs. Lezama caused her death. Well, that I have already addressed in the respondent's case. I ask the board to note as well that that is false, and it is not actually pursued by the appellant in his case, because both Rahim J. and the Court of Appeal found that Dr. Achong Lau's treatment of Mrs. Lezama caused her death. It is a concurrent finding. So that can go no further, respectfully. 6E, the Court of Appeal erred in failing to find on the preponderance of evidence that Mrs. Lezama died as a result of complications due to AFE, and that is really a summary of the several grounds that were already made in the notice of appeal to the Court of Appeal, but again, tied to AFE. In order to be unsettled on causation, the board would have to be invited to conclusively find that she dies from AFE. And the Court of Appeal, finally, 6F, the Court of Appeal erred in failing to apply properly or at all the Bolito standard as to causation. And this, whilst it is in the notice of appeal to the board, is not really something that could have been necessarily raised against Rahim J. in quite the same way, but I do ask the board to note that it is tantamount potentially to making a new argument before the board, because no other attack on causation was made other than the AFE-related attacks, as I've already set out. And whilst the Court of Appeal does engage in a review of the evidence, they affirm the findings on causation. They affirm several of the material underlying facts. And so in order to have appealed against the Court of Appeal on this, it ought to have been, at least in some related form, been raised at the Court of Appeal level, and it was not.
Well, I mean, your short point really is this, that you cannot say that the Court of Appeal erred in finding that there was a causal link between a non-AFE cause and the death.
Yes.
When that wasn't argued before the Court of Appeal. I mean, this is to say that regardless of whether AFE was involved, there weren't adequate findings of causation. That cannot arise out of any error on the part of the Court of Appeal, because the parties didn't engage on that point at all.
Yes, my lord.
So this is, if your analysis is right, this is a completely new attack.
That is my analysis, my lord. The secondary part of it is that it's not justified merely because the Court of Appeal engages in a review of the evidence. It's really their findings that you look to in the arguments that are made before them, and that argument is not made before them. There is no general attack on causation if it is not an AFE allegation. At the beginning of my learned friend's presentation yesterday, he did acknowledge that there are concurrent findings of fact, both as to breach of duty and causation. That is my position as well. We are agreed. And I would ask the court to note...
Causation insofar as AFE isn't part of the argument, you mean?
Yes, my lord. And the respondent's case, I direct your attention respectfully to page number 1211, paragraphs 48 to 42. And then on the issue of causation further, I say causation is an issue of fact. That is indisputable. And both the trial judge and the Court of Appeal determined that the appellant's breaches caused the death of Karen Lezama. They have therefore found, both of the lower courts have found, as a matter of fact, that his breaches caused the death of Karen Lezama, and they are consistent on several of those breaches, and so those are causation is a concurrent finding of fact. There are as well underlying concurrent facts on which the causation findings are premised. Electronic bundle page numbers 1214 to 1215, that is the respondent's case. And at paragraph 64 to 68, I set out those concurrent findings. So I do ask the court to note that in the absence of a successful appeal against the concurrent findings, there is nowhere to go on causation for the appellant. I don't want to read from the pleadings, but I would ask the court to note paragraphs 9, 10, and 11 of the statement of claim, electronic bundle page numbers 12 to 13, and paragraphs 15, 20, 21, and 22 of the defense, which is found at electronic bundle page, these are electronic bundle pages 18 and 19. Again, I'm not going to read from it, but at paragraph 15, the appellant asserts AFE as the cause of death. He goes on to tie, at paragraph 21, his denial of liability for causing the death after repeating paragraph 15. So from as early as the pleaded case, the position has been by the defendant that I did everything I could, I gave enough blood, she died from AFE, it was inevitable. That is the thrust of the defense. It is the defense he attempts to prove. And I say, because there was discussion yesterday as to this burden of proof. And I maintain that he who asserts must prove. The cause of death disclosed to the claimant was contained on the death certificate.
Well, that's not right, though, is it? Because even if he fails to prove AFE as the cause of death, he might still succeed in doing enough to achieve the position where you have failed to establish that your explanation is the more likely cause.
If he had done enough. But that is respectful.
I mean, it's not often that it turns on the burden of proof, is it? But
no, but I mean specifically in relation, respectfully, my lord, specifically in relation to the AFE, it is not the obligation of the claimant to disprove it. The manner in which it is pleaded and put into evidence by the defendant appellant, he has said, this is what it is. It was AFE. There was nothing more I could do. It would have been inevitable. That's his case.
But in principle, the court could be left in a position where he has not managed to prove that case, but nor have you managed to prove that,
and I accept that.
The alternative is more likely, and therefore you lose.
I accept that, my lord, except that it doesn't occur. No. Because
the key point was the one that we were discussing earlier, that the parties didn't engage swords on causation, if on a lack of causation, if the cause was not AFE.
Yes, my lord, and that is my position. So when I raise it on the burden of proof in relation to AFE, I say that if the defendant wished to succeed on saying that the AFE caused the death and the death was inevitable, that he had to prove that, and that there isn't evidence before the court to prove that. There wasn't evidence before the trial judge. The Court of Appeal rejects the evidence on AFE, but had they been able to, they reject the evidence, and now what really the board is being asked to do is to set aside the finding of the Court of Appeal, substitute your own finding on AFE, and I begin by saying there is not any sufficient evidence. There is no argument before you that would justify that course of action, but there is not sufficient evidence before you in any form for you to have substituted that finding of AFE. I take the position with respect that I don't need to re-argue causation before the board from the perspective of a non-AFE condition. I take that position. And that in the absence of the appellant having properly challenged causation at the Court of Appeal stage and before the board, and in the absence of the appellant having provided any argument to the board that would justify departing from concurrent findings of fact, and I have already made reference to there being several concurrent findings of fact on causation, including the fact that it was causative, then I don't respectfully consider that it arises. I'm prepared to address the board on aspects of the evidence and the judgments of the trial judge and the Court of Appeal, but in my respectful view, there is no need to go into it because of the point that I've already established today, and that it would not be necessarily proper to do so in circumstances where the appellant has not demonstrated that the board should depart from the concurrent findings, from its own settled practice. But I'm guided by the board.
Well, it has to be your decision whether you wish to put that material before us.
Yeah.
Well, I will, out of an abundance of caution, and because I still have an hour and a half, or is it just an hour?
It's an hour, not an hour.
I've never been here before,
so, to his half hour.
And I don't know when I'm coming back. I would begin by referring to what I extracted from my notes of the questioning of my learned friend yesterday. Again, Lord Legat, if I misquote you, I apologize. Does this go to causation only or also to negligence? And that was in reference to AFE. My learned friend's response was that it was more heavily weighted to causation, but goes to negligence as well. He was asked by Lord Legat how, and he responded, "It is not helpful for the court to overly separate the two questions. And if I could give a demonstration, I will not go into the demonstration, but arising therefrom is a question from Lord Hodge. Does it make any difference whether it was AFE or DIC/PPH in relation to the obtaining of blood?" And the response given is, "I will come to it." I respectfully submit that my learned friend does not come to it. The failure to obtain blood, sufficient blood and in a timely fashion, is a concurrent finding of fact. Blood and blood products, it is a finding of both the trial judge and the Court of Appeal, and it is a finding that is premised not only on the evidence of an expert for the claimant, but also on the appellant's own expert witness, Dr. Jabode. I don't want to belabor the point, but despite the inadequacy of his instructions, Dr. Jabode conclusively states at several points in his report, in close succession, that more blood and blood products needed to be administered. He accepts that they may not have been available, but again, that is attributable to flawed instruction. Similarly, Dr. Mary Singh Bola conclusively answers this question. Electronic bundle pages 916 and 917. And she says, pardon me. Red cells within the blood is what transports oxygen around the body. With significant ppH, the oxygen carrying capacity would be severely compromised, leading to hypoxia, multi-organ damage. Example, brain injury, acute renal failure, etc. The sooner that blood and blood products are replaced, the less is the risk of organ damage and death. The confidential inquiry into maternal deaths, a report produced every triennia in the UK, has consistently highlighted that one of the major factors in the adverse outcomes associated with severe hemorrhage is a delay in initiating appropriate management. So she addresses both the need for blood and blood products, the risk of organ damage and death if it is delayed, and she refers to literature which highlights that this is one of the major factors in adverse outcomes. So she identifies that an adverse outcome is more likely to occur if the blood and blood products are not replaced soon. And in this case, they were not replaced soon. Mary Singh Bola's evidence and Dr. Jabode's evidence were canvassed in the judgment of the trial judge and the Court of Appeal. My learned friend I said that it was a recitation, but both the trial judge and the Court of Appeal actually engage in a review, and when they set out the evidence of these experts, it is a synthesis really of the evidence that emerges following evidence in chief, the actual submission of the report, and cross-examination. It's not just a recitation. It is a consideration of all that has been said, presented in a form that is comprehensible and that shows what they accepted. Both experts, and the references are, pardon me, in the judgment of Rahim J, electronic bundle pages numbers 68 to 78, in particular, paragraph 55 at page 73, page 76, paragraph 62, pages 77 to 78, paragraph 68. Dr. Raul Jabode, judgment of the trial judge, electronic bundle page numbers 90, it starts at page 93, paragraphs 135 and 136, and page 94, paragraph 139. I believe paragraph, 135 and 136 are at page 94, and paragraph 139 is at page 95. In addition, the review of Dr. Harold Chang's evidence by the trial judge. Dr. Harold Chang, I asked the board to note, unchallenged largely, he arrived, the intravenous access was not working. That's confirmed on the medical notes. I apologize, I don't have those references. I don't seem to have saved those references, but it is there that he came and he immediately had to use his efforts to rectify the IV access.
We've seen that, thank you.
This is a very important concurrent finding of fact that has never been challenged, that there was an IV access that was not operating. That is a concurrent finding of the trial judge and the Court of Appeal. It's very important. Resuscitation is acknowledged to have been a very important consideration in the care of Karen Lezama. Resuscitation undertaken by an anesthetist is recognized by both Jabode and Mary Singh-Bola. I've already dealt with the evidence of the appellant and the evolving position on the request for assistance, but I do ask the court to note, as I've referred in the respondent's case, that it is an evolving position because previously at the appellate level, there was a complaint that he was single-handedly dealing with everything. And that is not consistent with any submission being made before the board that he called for assistance or that it was done at his instance. The additional paragraphs of Rahim J's judgment on causation at pages 119 to 122, with specific reference to paragraphs 219 to 224. This is where the Bolito test is set out. My learned friend says he does not disagree with the law, but the analysis is not enough. I disagree. I have already made my submission on the fact that causation is not challenged to the Court of Appeal, but in relation, for the sake of argument as we are here, the judgment of Rahim J and any trial judge or any first instance judge does not fall to be analyzed or scrutinized according to a rubric where he sets out the law on causation and summarizes his findings on causation. The judgment has to be looked at as a whole. It is a comprehensive judgment in which he engages in a substantial discussion on the evidence. It cannot be divorced. He's not obliged to then repeat in the section under the rubric causation all that he found that he has already dealt with in several paragraphs of his judgment. So that I asked the board, subject of course to my preliminary submission that there is no basis on which to interfere, with the findings of fact, that taking the judgment on a whole, reading it in its completeness, there is no basis for criticism of the trial judge's judgment on causation. Similarly, the Court of Appeal does not need to have a rubric at all. Again, it engages in an extensive review of evidence. It sets out its conclusions. The evidential review spans electronic bundle pages 226 to 251, paragraphs 23 to 56. Dr. Mary Singh-Bola's evidence scrutinized. I know my friend said recitation. I've already made my point on synthesis. Electronic bundle page numbers 241 to 245. I draw the board's specific attention to paragraphs 32, paragraph 34 at page 242, and paragraph 39 at page 245. Dr. Jabode, judgment of the Court of Appeal, electronic bundle numbers 249 to 251. Dr. Harold Chang, electronic bundle numbers 269 to paragraph 92, and additional paragraphs of the judgment of the Court of Appeal which deal with causation, pages 271 and 272. In addition, of course, to the analysis they make of the findings of the trial judge, those that they agree with. And to refer back again to the submissions that ensued yesterday by my learned friend.
Just before you leave the Court of Appeal judgment, you didn't refer us to paragraph 38. You didn't regard that as significant on the causation issue. I mean, that's their synthesis as you've described it. But they're saying that Dr. Singh Bowler has thought about AFE, but concluded the more likely possibility was that of PPH leading to DIC and ultimately death.
I want to make sure I'm in the correct judgment. I apologize.
Sorry, page 245 of the electronic.
245, very grateful. Yes. Dr. Singh Bowler concluded that it would not have been possible. Yes. I do regard that as...
Did she somewhere say that AFE was rare?
Yes. Dr. Jabode says that it is rare.
Dr. Jabode?
Yes. The appellant's own witness.
Thank you.
And he did say that in the course of his own career that he had seen only one case. On the issue of rare, another submission that my learned friend had made yesterday was that the blood type O negative was a common blood type, but it is not. It is the universal donor, but it is not common. There is no evidence before the board at any rate of that, but insofar as it in any way may weigh upon the board, it is not, that is not accurate. Sorry, returning to the submissions yesterday,
Could you just give me the reference for where Dr. Jabode
I can.
said that when you've got a moment? I don't want to interrupt your flow now.
No, that's all. I can get it for you now. It is at the syndrome is uncommon in an absolute sense. However, it is a common cause of maternal death.
So could you please give me the page reference for that?
It is electronic bundle, page 948.
Yes, he's
Quoting.
He's quoting from Williams Obstetrics.
Yes. I believe he does also give the evidence that it's in his cross-examination that he also gives evidence that it is not common. And I'm sorry, I don't have...
And presumably it's there, he says he's only saw one case of it ever, is that?
Yes, he does say that.
In cross-examination?
In cross.
At some stage, you could just give us the reference to that. Not now.
I will.
When you get a chance. Thank you.
Before I am obliged to leave today, I will do my best to provide it. And the reference on Dr. Chang's evidence of the only one drip working is at the electronic bundle, page 711, paragraph 2. That's his witness statement. In the course of submissions yesterday, Lord Hodge, in reference to Dr. Jabode's report, and again, I apologize, my lord, if I misquote you in any way, but I believe that you had actually quoted from Dr. Jabode's report where he says this is a rare event, the AFE, because one would not expect to have blood on hand, and the inference is that blood was needed.
Well, the evidence of Dr. Jabode, to save you coming back, on page 95 in the first instance judgment, para 137, he explained in cross-examination it occurs 7 per 100,000 deliveries worldwide. In his 20 years of practice, he'd only encountered one such case.
This is
page 95. He found that one practitioner, that's Dr. Lowe, experiencing 5 such cases was unusual.
Yeah. Thank you, my lord. And finally, in my note, Lord Hodge, I have you as saying that the expert, with reference to Dr. Jabot, does not say that it would have made no difference, the AFE, that it would have made no difference. And I assumed that was to the outcome. And the answer that I wish to give is that the report, he does not say, on my review of his report and the cross-examination, he does not say that it would have made no difference. And the inference that arises from his repeated references to more blood and blood products being needed is that it would have made a difference. And in terms of the, just very quickly back to Dr. Jabot, the cross-examination page, Lord Burrows, is electronic bundle page 673, and it is lines 1 to 16.
Thank you very much.
Thank you, my lord. I had sent 2 judgments this morning. I apologize. I don't know if they've been provided to the board, but they were
2 authorities.
2 authorities. Williams and Bermuda Hospitals Board, and Ming Su Hung and others, and F. Ming Incorporated and another.
Have they been supplied to your opponents?
I'm not certain. I did email it to the registry and I copied it to my friends, but I don't know if that was the appropriate course. I just assumed.
When did you email it to the registry?
Approximately 8:40 this morning.
This morning.
I think it hasn't made its way to us.
I'm not aware of it, but if you give us the reference and a clear indication of the passages that you're referring to, we can look at the material when we receive it.
Very grateful, and I apologize for the late submission of the authorities. The Ming Su Hung and others and JF Ming Incorporated is a case of the Privy Council. And I will give you the reference. It is 2021 UKPC 1. And the relevant passage, the relevant paragraph rather, I apologize, is paragraph 20. And it is where the court sets out the well-settled constraints upon appellate jurisdiction when asked to re-exercise the discretion conferred upon the first instance judge.
Well, this isn't a discretion case, if that's
the Justice Barrow dealt with, Justice of Appeal Barrow dealt with appellate restraint in relation to the findings of fact issue with Beacon. And I'm aware it's not a discretion case, but I did want to commend to the board that the principles of appellate restraint are still pertinent.
Evaluation of evidence which may not be entirely consistent.
Yes.
It's not a discretion.
Does that apply in the same way, do you submit, when it's an appellate court reviewing conclusions reached for the first time by another appellate court, a lower appellate court? They're not in the same position as the judge who heard all the evidence and had the full
I recognize that, my
picture.
lord.
So perhaps one might be more willing to bit readier to interfere with their evaluation if we thought it was wrong, given that it was an appellate evaluation itself.
Yes, my lord, I recognize that. I do not believe that it is wrong, but I do understand on that basis that if one appellate court has interfered with a finding of fact, but I would ask the court to note that the Court of Appeal actually makes a finding of fact. They do
that's what I'm addressing, that they made findings of fact which weren't made by the judge.
which was not actually made by the judge.
Not actually made by the judge.
Yes. And then Williams and Bermuda Hospital, I thought would just assist further on the authorities on causation. I had not put the authority before the board in relation to causation. I had intended to, and I do apologize, it was an omission. Which really just is an authority that deals with the fact that where on the balance of probabilities an injury had been caused by two or more factors operating cumulatively, one or more of which was a breach of duty, it was immaterial whether the cumulative factors operated concurrently or successively, that although the sequence of events might be highly relevant in considering as a matter of fact whether a later event had made a material contribution to the outcome, or conversely, whether an earlier event had been so overtaken by later events as not to have made such a contribution, those were evidential considerations. And once, and just to paraphrase at this stage, as a matter of principle, if there was each was capable of making a material contribution to the subsequent outcome, my apologies. Essentially, once there is on a balance of probabilities that the defendant's negligence had materially contributed to the process, then there is liability, there is causation established. Now, this is, of course, this submission is subject to the position that AFE has not been identified with any degree of evidential certainty as a possible outcome. But insofar as the Court of Appeal, on an alternative basis, found that even if AFE had been diagnosed, there was negligence.
We've been given these authorities, they seem to have come through now by email.
I'm very grateful. That even if that it was nonetheless, his treatment was causative of her death, because it would have been material. Incoming, I once again ask that the board have regard to the respondent's written case. I ask that the court note, again, that the notice of appeal, that there are material differences between the grounds as pursued in the notice of appeal and the appellant's case. I ask that the board dismiss the appellant's appeal with costs. And I would ask the court also to turn to electronic bundle page 1196 at paragraph 103, which is the conclusion of the appellant's submissions. In conclusion, the appellant respectfully asks the board to consider all the overlooked evidence as set out in these submissions and set aside the lower court's fresh and concurrent findings of negligence and causation, and instead find that the appellant was attentive to the emergency and did all that he could have done to save Mrs. Lezama with the limited resources available on a Sunday evening at a maternity clinic with no ICU nor blood storage facilities, and that despite his best efforts, Mrs. Lezama unfortunately succumbed to AFE. It's quite a request to make of the board. And I respectfully submit that despite the reference to the case, the appellant has actually not demonstrated that there was overlooked evidence. The appellant has not brought the case, his appeal, within the exceptional circumstances which the board has prescribed for interference with concurrent findings of fact. The appellant expressly recognizes that there are concurrent findings of negligence and causation. Any reference to limited resources available on a Sunday evening at a maternity clinic with no ICU nor blood storage facilities, I respectfully submit, is irrelevant. It is not a matter that was canvassed thoroughly in any evidence. It is contradicted by evidence that was led. It is contradicted by the appellant's own evidence. He always had access to blood. He demanded it, he received it. And I ask the board to note that the appellant ends by saying, despite his best efforts, Mrs. Lezama succumbed to AFE. And that, as the last line of the appellant's case, is consistent with the respondent's submission that has been made from pleading to evidence to appeal to the Privy Council. The appellant has been saying, it wasn't me, it was AFE, and he has not demonstrated that. The findings of the trial judge on negligence and causation are affirmed by the Court of Appeal. Any review of the evidence undertaken in relation to material errors identified by the Court of Appeal do not unsettle the trial judge's decision. They affirm the decision on every material ground. And in those circumstances, I respectfully ask that the board dismiss the appeal with costs. And unless I can be of further assistance, those are my submissions.
Can I just ask, as a matter of terminology and getting the clearest terminology, how would you express the opposing descriptions of the cause of death? Is it best to say, on your approach, on your submission, that we're contrasting AFE-induced DIC as against PPH-induced DIC, or would you formulate it in some different way?
That's exactly as I would formulate it. PPH-induced DIC versus AFE-induced DIC. There is an additional reference that I was to provide, electronic bundle 272, paragraph 98.3, reference to the Court of Appeals decision, which the board also noted yesterday, that even if it was AFE, the treatment still fell below the BOLAM standard. Thank you.
Mrs. Yes, I see that's 98.3. There seem to be no further questions. So thank you very much. Mr. Benjamin.
My Lords, can I begin just because I don't want to overlook it? You had asked me a couple of housekeeping questions, my Lord Leggett, in relation to, I think it was the Coroner's Act.
Oh, yes.
The Coroner's Act is in the Joint Bundle of Authorities. Can I be forgiven for not taking to the relevant paragraphs? There is an additional statutory authority that might bear on that question. There is a piece of legislation called the Private Hospitals Act. So with your leave, and only with your permission, I'll provide you with it, simply for giving you the reference for the purpose that the supervisor or the person in charge does have the power to make a reference to the coroner. But in the following context, it normally, and I'm dealing with both pieces of legislation now, just for your note, normally it arises if there is an unnatural death, a death connected with violence and so on. But the gist of what I said to you yesterday remains accurate. That is to say that it's for the family. First of all, it's for the district medical officer to initiate the autopsy process. And that cannot happen if, in the ordinary course, that is, it does not happen if a family member objects. So the family and the district medical officer are the ones who have primary, as it were, a role to play. My Lord, I think those were the only housekeeping questions that you had for me. And I think I did respond to Lord Hodge yesterday when I came back after lunch.
Yes.
My Lord, there's a lot of reference to detail and references to the evidential material. And of course, I won't be able to deal with every single one of those references in the limited time. But can I begin really with Lord Burrows' question? And I want to use his question as a launching pad to give two answers. So my noble and learned Lord Burrows put to my learned friend whether or not the case can be articulated, and I'm just making sure I have an accurate note, as either AFE-induced DIC, and this is my note, or PPH-induced DIC. And so, my Lord, respectfully, and my learned friend's response to that was positive. The difficulty with that way of articulating the case is that it doesn't take account of what is the agreed evidence, which is to say that on the death certificate, it is both DIC and PPH. So that when the alternatives are put in those stark ways, it doesn't account for the agreed material. And so we say that it's an understandable temptation to articulate the question in that way.
But Lord Burrows was asking not about what was on the death certificate, but what
Yes.
the parties' cases are
Absolutely.
this appeal. And the Court of Appeal found, and I take this to be the claimant and respondent's case, is that the more likely cause of death was massive PPH brought about by uterine atony, leading to DIC and ultimately death. That's page 272.
Yes.
And what would be very helpful is if you could confirm what you say is your alleged mechanism which led to death. Is it AFE causing death by way of DIC, or is it, or does AFE have some separate causative impact?
I'm sorry, my Lord, I didn't mean to interrupt you. I apologize. No. My Lord, my direct answer is that it is AFE-induced DIC, exactly as has been articulated. But I simply don't want to leave out the fact that PPH was present, and it's in that context I want to take you to two pieces of evidence, or two aspects of the record. The first is the agreed statement of facts and issues at paragraph 12 that my learned friend said she read to you, and you'll find that on page 1152 of the record. It's in the first sort of 3 pages of your key documents bundle, if you have it to hand. And it's internal page numbering 2, internal page numbering 2. So it reads, immediately upon delivery, Mrs. Lezama began bleeding significantly as estimated by the appellant at 500 cc's. I'm just pausing there, and I am going to take you to the appellant's transcribed note in the Court of Appeals decision next. But what follows is important. Her blood was initially thick and red, and my friend read that, but she didn't read these words, and became pale pink and watery as the bleeding continued. Pausing there, DIC. So we say that the evidence and the findings of the Court of Appeal as to the reasonableness of the existence of AFE are entirely consistent with its obligation, so forget about whether it comes out in my favor, its obligation to consider, again to borrow Lord Burrows' aphorism, the AFE-induced DIC case. So leaving aside, and this is important, leaving aside anything that the appellant had to say, it is the objective evidence derived first of all from the nurse's notes as to what was there, their analysis and their recording of the Mrs. Lezama's blood pressure, the recording and analysis in due course of the difficulties that she had in breathing, and I'll come back to ambubagging in a minute. And that, therefore, is tied together with the expert evidence of Dr. Mary Bola Singh and Dr. Jibod that all say that AFE was an entirely reasonable conclusion from the data This is nothing to do, this is important. This is not, in other words, this is not a question of corroborating that which Dr. Achong Lau said. This is derived from their analysis of the data. And so that I can clear it away, whether their instructions were limited or inadequate or whatever, at the end of the day, each of these experts, whether prompted or drawn to that position by cross-examination, all of them had access to the agreed bundle of nurses' notes, and all of them, this is not one, all of them came to the AFE conclusion as to its reasonableness. They could have been asked whether AFE was an eccentric, irrational, unlikely explanation as to the occurrence, and they didn't give that answer. And they could have been asked they could have been asked the very question captured by Lord Burroughs' aphorism, i.e., that this was a case of PPH-induced DIC. And as a matter of fact, the way that the case was put, and which is why we had argued strenuously that it was a false question, was that the way that the case was originally put and analyzed both by the first instance judge and the Court of Appeal, it was as though it was a straight contest between AFE and PPH. That way of putting the case, with the greatest of respect, does not have the sophistication of the way that Lord Burroughs has articulated it. I promise to take you next to the note of the transcribed note of the appellant, reproduced by, I think it's 227. Yes, I apologize for that delay. I promise to take you to that note. And I just wanted to do so for the purpose of making a small point about PPH in this context.
Which page, sorry?
I'm sorry, Electronic Bundle 227. I'm on the judgment of the Court of Appeal. It is paragraph 23. And it's over on the right-hand page, the italicized passages. I'll just wait for you to all have it in front of you. But I can make some prefatory comments. Now, my learned friend has relied upon, and yesterday we traversed similar ground, from Dr. Singh Bola about this UK study which says that, it is a problem that clinicians can underestimate blood loss and so on. And in support of an argument that essentially amounts to, well, there has to have been much more PPH than everybody wanted to let on, my little friend has taken you to Mr. Brian Lezama's account and Dr. Manning's account, etc., etc. So I just wanted to draw this passage to your attention and make a couple of submissions on it. Which is to say that what Dr. Achong Lau is doing here is, right after the passing of Mrs. Lezama, he sits down to write a note, and you've seen it in his handwriting, and it's here transcribed. Patient demise at 10:10, so that confirms it's an ex post facto note. After delivery, post-death note is all I mean by that. Right? Delivery occurred at 4:53 p.m. Almost immediately upon delivery of appealing stillbirth, there was significant bleeding, which after repair of immediate laceration of the posterior fourchette, the PPH was controlled by intravenous syntocinon drip and fundal massage. And so what he then does, he says approximately 500 cc's. Now, without having drawn your attention to any cross-examination evidence seeking to undermine his estimation of that, or approximation of the blood loss, there was an attempt to attack it. But even if that cross-examination had taken place, which it didn't, one still has to contend, and so I'm on my AFE versus PPH point, one still has to contend with the very helpful table that I drew your attention to yesterday, provided by Dr. Singh Bola, which I say establishes or supports the appellant's thesis, together with what was observed contemporaneously, that the blood loss that had occurred, and I want to be perfectly fair and remind the board that there was further blood loss referred to in this note, Let me just kind of pick it up. So as we go through, so the blood pressure is shocking and systolic. This is all at 5:15 p.m. You got that from the agreed facts and issues. Then he goes down to the fact that blood was hung. We know that didn't happen until 7:30. There's no complaint about that. There's a reference to Dr. Chan being present, and there's a reference to her being ambu-bagged. And all of the references in the notes to the patient being ambu-bagged, not just here, but in the nurse's notes, are only consistent with respiratory distress. So that you will see in the nurse's notes the fact that there's a reference to her being ambu-bagged. You were taken to that by my learned friend, and I'm saying the only thing that makes sense of those observations, of course, is that she has difficulty breathing.
But is there any evidence that that occurred before 7:30?
I cannot. I said this to you, my lord, yesterday, with greatest respect,
Yeah.
I can't. There's nowhere for me to point you to other evidence. There isn't any, and I'm not going to suggest that there is.
Okay.
And so I've gotten to 7:30. There is the assistance of Dr. Chang. Her oxygen saturation levels improve. There is a consideration about a decision to go to ICU that was put on the table. It couldn't happen because the patient began to bleed again. And you will see there was an explanation. I think it was my Lord Kitchen who asked, well, what does PV stand for? And there was the explanation. And she's bleeding from the venipuncture sites and orifices. That evidence, with the greatest of respect, is utterly and completely consistent with DIC as we discussed yesterday. So that in this case, DIC is not in controversy. It's not in dispute. The only question is what caused the DIC. And so that brings us to first to say two things. That question allows this court to exceptionally depart from its concurrent restraint practice as far as causation is concerned. I'm on reply. I'm not going to repeat anything that I said about negligence. I'm not going there. And we rely upon the fact that in this case, the Court of Appeal purported to make fresh findings so that even if you were unpersuaded as to your ability to free yourself from that constraint, and that's consistent with the authorities, including the most recent one that my learned friend referred to this morning. I think it's the Ming case. Ming says exactly the same as McGrady, and all of the cases are harmonious in that respect. But to the extent that you felt any restraint or constraint, that's overcome by the Court of Appeal's fresh findings, with the greatest of respect. It's perfectly proper for you to decide, either on a standalone basis or on a compendious basis, with the greatest of respect, whether the Court of Appeal went wrong or not in making those findings. And we respectfully submit that you should feel unrestrained in having a further look and examination of those issues as far as causation is concerned.
If your case is, as you confirm that it is,
yes,
that the relevance or significance of AFE was as a cause of DIC,
yes,
would it actually help you if we were to conclude that it was the likely cause? Because what you're alleging is that the mechanism of which resulted in death was DIC, and that wasn't addressed by getting blood. There's no reason on that basis to think that AFE would have caused death anyway.
Well, my Lord,
if the only way in which it did operate is through the clotting problem.
Well, my Lord, but that's actually not the evidence. The evidence is that clotting is one feature of AFE, and the evidence is that all of the other features that, again, I referred to yesterday, in particular cardiorespiratory challenges and so on, were present in this lady, and that they are consistent with AFE. So,
well,
my Lord,
perhaps you're not making a different submission. When I asked you earlier to confirm whether your case was that the cause of death was AFE-induced DIC, I wrote down that that was exactly what you did confirm, and that it didn't operate to cause death by other means.
Oh, my Lord, I'm sorry, my Lord. What I just said a moment ago was exactly what I said yesterday, I believe.
Well, I'm just wanting to understand what your final statement is, not what it may have been at different times.
My Lord, my case is, if the board is unconvinced that it's entitled to engage in a review, I lose.
Yes.
If the board is unconvinced upon a review that AFE was not established, I lose.
Yes.
So that my case is an AFE case.
Yes.
In answer to my Lord's question, is my AFE case limited to DIC? Limited to DIC? Absolutely not. I was simply answering the question as to whether or not it's helpful or important to identify as a question whether DIC was caused by AFE. That's all that I was responding to. My case is that AFE, in this case, consistent with the findings of Justice Rahim, caused A, DIC or a coagulation problem, B, cardiovascular problems, C, blood loss, and that those AFE-induced causes or consequences led to her demise. If you are against me in any one of those things, I'm out. If you find in my favor, as unpalatable as that outcome might appear, as far as Mrs. Lezama is concerned and her family, that's all that I mean, then I succeed. That's it, my lords.
Yep.
My lord, I hope that's, and I apologize if, and I'm not going to hold you responsible for the quality of the high quality of your questions, if I was slow to get the answer out. I thought that I had said all of this yesterday, and if I didn't, my lord, that's my case.
Thank you.
Yeah. My lords, on this, can I just ask you to look back at Dr. Gibaud's, and I'm really sort of report, going back to the exchange that I so very helpfully, with the greatest of respect, had with Lord Hodge. So this is 947, 948, and 949. And I'm just trying to make sure I find my note of what my learned friend had to say about this. So my learned friend and I have exchanged aphorisms, battle of the experts. The experts weren't battling, maybe they were, there was common ground and all the rest of it. But in support of the case that I have argued, and in support of seeking to persuade the board that it's entitled to come to a finding in my favor, I respectfully, in common with my learned friend, rely upon what is said by Dr. Gibaud at pages 947 to 949. But I wish to advance a contrary interpretation as to what is contained here, and ultimately that will be for you to decide which one of us is correct. But this, with the greatest of respect, is a pivotal piece of evidence, and we simply say that the thrust of it is entirely consistent with the following, which is to say that Mrs. Lezama did suffer from AFE-induced DIC, as well as the related features. So, my lord, I'm really sort of supporting my answer to my lord by reliance on what is said here. And you could pick it up in the middle of the page, at page 948, if my lady has it. Yep. Mrs. Lezama experienced consumption, coagulopathy, hemorrhage, and a drastic fall in BP, and cardiac arrest. Pausing there, which led to her demise. And this is consistent with the diagnosis of amniotic fluid embolism. And just leaving aside what he says about his recitation of what the appellant says, and then he gives the context. He explains why he's come to that conclusion in the next paragraph. He explains why he thinks it's a reasonable diagnosis. He talks about the abrupt onset of certain conditions, and then he goes on to talk about mortality. And so what we say is that there is evidence that was not contested. This evidence was not contradicted. It was not contradicted when he was cross-examined, and it wasn't undermined or qualified, and there isn't a sentence, and you will correct me and stop me dead in my tracks if I'm wrong, in the judgments either of first instance or the Court of Appeal that says that what I just said is inaccurate or unreliable. And then finally, my lords, I just want to deal with so I don't propose, as I said, to take you to the any further details of the record. What I do want to say is that in answer to what my learned friend has to say about shifting cases, shifting positions, and as far as the notice of appeal and grounds of appeal are concerned, most respectfully, the case that I have sought to advance is sufficiently covered by my grounds of appeal, paragraph 6 of my notice of appeal, as it was covered by my predecessor's notice of appeal to the Court of Appeal, not just the grounds upon which my learned friend relied, but also, in addition to 17, Roman numeral 17, Roman numeral 11, which my learned friend did not read.
Could you give me the page number?
My lord, if you bear with me, I'm going to do exactly that. It's in the vicinity of 125, 126, but Mr. Rudder is going to make sure I give you the absolutely correct one. So that's on page, yes, it's on page 130 of the electronic bundle. And can I just read the first sentence just to make good my submission?
This is
my Lord
round 11 you're referring us to.
Yes, Roman numeral 11. The little judge erred in law and in fact by failing to find that the deceased cause of death was AFE. So that's my case. So that, I mean, obviously you have to treat with all of these these arguments as to what's with the notice of appeal, and you will do so. But I just wanted to draw that to your attention.
Yes, so we are to understand, the board is to understand that you're not making an attack on causation or on the failure of the courts below to deal with causation if ASFE is not established as a causal factor. It is simply, you say that given what Dr. Jabode said, that the courts below haven't engaged with the possibility that AFE, or haven't engaged sufficiently with the possibility that AFE was a causal factor.
Absolutely, my lord. Yes. No FE, I'm out of court, and can I support it by simply reminding the board that the Court of Appeal agreed with the experts that it was reasonable. What they did not do, and I made all of this complaint yesterday, is go on to do the analysis. And so I don't want to distract my lords with a debate with my learned friend about recitation or rubrics or, I mean, these are just labels. At the end of the day, what my lords are looking for is a flaw in the reasoning. And this is the submission I made yesterday. If you find none, I lose. But I've tried to advance, both in my written case and in my oral submissions, the bases, not the basis, but the bases for those flaws. And I don't want to be taken to be engaging in an advocate's excessive criticism of the Court of Appeal. It only has to do with these errors in their approach to reasoning in a case which involved fairly complex medical matters, and at a time, and I accept this, I agree with my learned friend, Ms. Haddad, at a time when the capacity of both the bar and the bench to deal with the sort of complex medical negligence cases that you would think are routine was still at a time of development. That's all that it was. Different things happen in different cultures at different times. That's all that it is. It's not a criticism at all. But at the end of the day, just as I have to be held to a standard, and medical practitioners have to be held to a standard, there is no basis for not holding the Court of Appeal and the first instance judge to a particular standard as far as their analysis and their reasoning is concerned. My Lords, I don't know whether you want me to say anything about the two authorities. I'm not quite sure how you propose to deal with them. You've got them.
The ones referred to.
The ones referred to by my learned friend, that's all.
Well, I have looked at the first one on the internet, and it's merely a recitation. That paragraph is merely a recitation of prior authority about the grounds on which a court of appeal can properly intervene.
Absolutely, my Lord.
So I don't think it's breaking any new ground.
My Lord, it is not, and can I say there was nothing in that paragraph with which I wish to dissent. And my Lord, as far as the Bermuda case is concerned, I mean, I did have a chance to read it before you came in, and so what I'll say about it is this, is that that case, with the greatest respect, makes precisely my point about analysis, because that was, when you come to look at Lord Toulson's judgment on behalf of the board in due course, you will see that he engages in precisely the kind of analysis in order to come to a conclusion as to causation, as I say should happen in this case. So I don't have any difficulty with the case. It doesn't help you decide the case one way or another, but insofar as it's an illustration or an example of, in his case, upholding, I believe, the Court of Appeal, who had overturned the first instance judge, I have no difficulty with it. I've got 3 minutes left, but I don't propose to stand up and torture you any further, other than to thank you for the meticulous attention that you've paid to this case. I hope I can speak on behalf of my learned friend in that, to say that we are immensely grateful. It is always a privilege and a pleasure to be here, notwithstanding the bowling that comes from those of you who have the cork ball in your hand. Thank you so much.
No questions to you, Mr. Benjamin. Thank you very much indeed.
Right.
Well, it only remains for the board to thank counsel for their clear submissions, and also, not to forget, and thank those who have assisted counsel in the preparation and the presentation of their cases in this appeal, which concerns a very sad event. The board will take time to consider their judgment and will now adjourn.